webinars, etc. So this is actually my first hybrid event. And let me just rephrase that. It's the first time in 2 years I've spoken to people in person. So please bear with us. We're working with the technology. We're working with all of you here. We're very happy to see everyone. I am not giving the opening, but I have to give the prompt to my lovely colleague, Michael Chick, who is going to give the opening. Michael, when you're ready.
Good afternoon to our participants in Asia. Thank you everyone for attending today's hybrid event on the future of international arbitration in light of COVID-19, which I believe we have a very exciting and insightful panel today. By way of introduction, my name is Michael Chick. I'm a litigation arbitration partner and witness. We are very delighted to be hosting this event and to be one of the event sponsors at the Hong Kong Arbitration Week for the very first time this year. This is an international law firm with 18 offices worldwide, with 3 offices in Asia, including Hong Kong, Singapore, and Tokyo. With over 180 partners and more than 500 other lawyers, we are trusted advisors to the world's successful people, business, families with complex legal needs. Our dedicated arbitration team works with clients around the world to resolve major commercial and investor-state disputes across a wide range of sectors. We are also one of the leading firms acting for some of the most high-profile and dynamic clients in this market. Our lawyers also serve as arbitrators from time to time and are prominent as sports leaders in the field. As a testament to our commitment to the international arbitration community and space in Hong Kong and globally, we are very delighted to take part at this year's Hong Kong Arbitration Week. The topics in this year's lineup have been carefully curated to spark important conversation and facilitate learning. I hope that you will benefit from this discussion. And now I shall pass the time to my colleague Sharon Tong, who will be introducing our esteemed speakers.
And there you guys have it. You come back to me again. So again, welcome to Withers. We're very excited to have everyone here, or at least everyone here in person and also everyone virtually. We've got a good crowd. Our understanding is the 10th annual Hong Kong Arbitration Week has had a record number of registrations. Eric is going to correct me if I'm just making this up. No, but it is a declaration, so this is great. And so that means we actually have a number of people also joining us online, including for our panel. Before I actually introduce, does somebody want to meet the computer? Before I actually introduce our panel, sorry, Helen, mainly we have echoing here, so this is why I keep stopping. So before I actually introduce our panel, I kind of wanted to introduce what today's session is about. It's something that I'm sure is not new to any of you. We've heard about COVID for 1.5 years, 2 years now. We've heard about what everyone thinks the new arbitration world will be like. We've heard about the impacts of arbitration or on cross-border litigation and disputes or cross-border relations. But what we wanted to gather today was a brilliant group of panelists who would give you not only, their insights from their personal experience and also professional experience, but also what they believe is going to happen in the future of arbitration, and why don't we add to that just cross-border relations. We have perspectives here today from mainland China, from Hong Kong. We've got perspectives for people who have clients from all over the world. So we think we're going to give you quite a good angle, we hope, or we're also very happy for you to correct us or give us something to think about and discuss during this panel. The idea is to make it a very interactive panel. As much as I love to hear my own voice, I would much prefer to have you guys speak with me and speak with us, because we haven't seen a number of you for years now. Before moving forward to the actual discussion or the panel, I would like to introduce our amazing speakers today, our very distinguished speakers, of which I am very honored to be able to moderate. So I'm going to start in alphabetical order based on last name, and I'm going to start with Mr. Joseph Chu, sitting all the way over there on my left, your right. Joseph is a partner at Withers, and he has extensive experience in cross-border commercial litigation and arbitration, cross-border disputes, investigative matters, and regulatory matters. That's just to say the least. He actually has over 2 decades of experience. Joseph has joined us here at Withers, and we're excited to invite him, or not invite him, welcome him on board as of September of this year. That's right, yeah, he'll be here for many, many years after that. Joseph is one of the authors of the Sweet Maxwell's Arbitration in Hong Kong, a practical guide, and he is also qualified in Hong Kong, the UK, or let me rephrase that, England and Wales. And he's also done a rare feat. He's passed the PRC bar exam, which is extremely difficult. Not the Greater Bay Area one, guys. I mean the actual PRC bar exam. Now, moving on, I've got Mr. Eric Ng. Do I ever say that right?
Yes,
I'm close.
that's right. Yeah.
Okay, Eric and I go back many years. Eric is managing counsel at the HKIAC. If you are not familiar with him, he was previously, before that, a barrister here in Hong Kong. I've been told I need to speak closer to my microphone. Is this better? Great. Sorry. Previously a barrister here in Hong Kong, where he focused primarily on international commercial and construction disputes. Eric also is qualified. You are qualified in Hong Kong. I was like, oh. But the great thing is he was educated in the US, the UK, and Hong Kong. Now, moving on to Ms. Helen Shi, up there, over there on our screen. Very lovely. So Helen is joining us from Beijing today. Helen is a partner at Fangda Partners, and she's recognized by Chambers and Partners as one of the icons of arbitration. She also has significant experience in dispute resolution. Helen is, and I can be corrected if I'm wrong, but I'm pretty sure she's the first ever vice president of the ICC court from PRC China, or from the mainland. And Helen is qualified in both China and New York. Now, last but not least, we're going to move on to Dr. Mingli Teng, also up there, over there. But Mingli today joins us from Shanghai. Mingli is a senior associate at Albright Law Offices, and she's extremely experienced in cross-border disputes, not only in China, but also has handled cases in the English High Court and the Court of Appeals. Mingli also advises on domestic PRC and foreign clients on PRC law, and she is also qualified in the mainland China and New York. Mainly, you can correct me if I'm wrong, but I found also very interesting that you were educated in the US, PRC, and also the UK. It's like all of us were educated in many different places. So, without further ado, I am going to go ahead and continue this wonderful panel and reiterate that we really would appreciate an interactive session. So for those of you that are here in person, please take advantage. Raise your hand, say something. If somebody disagrees with something that's said or you agree, please go ahead and chime in. But what I'm going to do first is I'm going to start with a question to our panelists. As all of us know, COVID-19 hit the world in tranches. I think all of us here in Asia had an inkling that something was wrong or something was up around December 2019 or January 2020. Now, I recall at that time I was still traveling. I was still able to go to Europe with no problem. In fact, my husband didn't want me to come back to Hong Kong because he thought it was going to get out of hand. Interestingly enough, in March 2020, it was declared a worldwide pandemic. But given that this COVID-19 situation has happened in tranches, one of my questions is, Asia was the first to shut down, but Asia was kind of also the first to open up again, although I know that is questionable with how we're all stuck here in Hong Kong. I'm going to throw this question first at Joseph. How does the COVID pandemic actually impact your line of business and your profession?
I think in terms of business of law firm, different practice area are affected by COVID to a varying degree. Some good, some bad, but overall, the legal demands does not shrink. In the early days of COVID, the transactional work slowed down, but at the same time, there has been an increasing demand on the restructuring and insolvency side. The court closed, the hearing adjourned, but there has been an increase in the amount of litigation. So disputes tend to arise in bad times. So overall, we see the legal demand are still there. And law firms are not that badly affected. A lot of changes need to be undertaken, but the law firm not badly affected compared to other sectors. Now, in terms of the way we work, we change a lot. I mean, work from home has become the default mode. I remember last year, most of the time I spent working from home. We also changed the way we interact with clients. So traveling basically are not possible these days. We can't see client face to face. And mostly, at least for last year, we have been communicating with client mostly by way of the new technologies, Zoom or by emails. But from overall, I think the legal industry has changed a lot over the past year, but it is not badly affected when compared to other sectors.
Thank you, Joseph, and I would agree. That's your perspective because you oftentimes go back and forth between Hong Kong and mainland China. So why don't I actually turn? I'm supposed to look at that camera over there. Helen, I'm going to ask you, since you were in China since it started, and I'm assuming this entire duration, how has this COVID-19 pandemic impacted you in your profession, also perhaps with your clients, and what say you? Helen, hold on 1 second, we can't hear you.
I'm unmuted. Okay, so you can hear me now. Thank you for your invitation, Shirley. You may recall, it was January 23rd, 2020, where Wuhan, the city in the middle of China, was locked down due to the spread of the virus. It was one day before the Chinese New Year Eve, where most of our lawyers had already went back to their hometown to be with their family members for a 7 days holiday. So our office supposed to resume work on February 1st, but in order to protect our lawyers and staff, the partner had an emergency meeting and decided to ask all our employees to stay to work remotely. And
Sorry, Helen, we're having slight technical difficulties. Oh. I think, does that mean she can keep talking? Yep. Yeah. Helen, keep going.
a month, and then we started to resume to work in early March by taking 2 separate shifts and adopting other policies, in order to cope with COVID-19. Until June, we fully resumed our normal work. So I would say from February to May, our office, our routine has been affected, but we never stopped working. The business for law firms are actually increasing in 2020, in fact, especially for dispute resolution and the insolvency practice. So the event of breach of contract has been increasing, so clients need more lawyers to work on disputes. According to the statistics published by the PRC Ministry of Justice, the civil cases handled by PRC lawyers had been increased from 4.79 million cases in 2019 to 5.32 million in 2020, which is 11% growth in the number of the cases. So I would say, legal practice is not affected that much by COVID-19.
Thank you, Helen. Wow, that's an 11% increase in the time of a pandemic. A lot of people would think otherwise, given that you get stuck at home. Let's take a turn a little bit. Let's take a look at maybe the institutional view, because Eric, even though you are part of the HKIAC and based in Hong Kong, your workload or your caseload is worldwide. So particularly given these different tranches of when COVID hit, what are your thoughts?
Hi, thanks, Sherlyn. And I think HKIAC's experience is actually representative of both what Joseph and Helen has mentioned. Helen mentioned an 11% increase in cases, and Joseph had said that the arbitration and litigation practice didn't really stop. And in truth, from the institutional perspective, that was correct. In 2020, actually, HKIAC saw a record number of cases registered, with the center in terms of under its administered arbitration rules, under the UNCITRAL rules, in ad hoc appointments. So what we could see was that the disruption of the pandemic actually caused significant issues which then still had to be arbitrated. And the question for the institution was, for an institution which prides itself on being able to be efficient, on being able to be cost effective, being simply postponing a hearing for a course of a year or until an indefinite date for the pandemic to end simply wasn't an option. Now, Hong Kong also had both the fortunate and unfortunate position of being on the leading edge of that COVID wave. And as Helen had mentioned, this really started to come into light right before Chinese New Year. And so what we had, even within that Chinese New Year week, when many of the parties should have been on lunar holidays, was questions, emails, phone calls to the institution. What is going to happen to this hearing? Can we still proceed? Is HKIC going to shut down? Is Hong Kong going to shut down? And so from the institutional perspective, we were put in a position where we had to come up with answers on how we would continue doing international arbitration when you weren't able to travel internationally, when things were shutting down and people were working from home. And I think one of the, why I say that was also partially fortunate was that that also gave a signal to us as an institution to say that we need to be pressing forward with ways and methods of making sure that we can continue offering services even in the light of a COVID worldwide pandemic and subsequent disruption. And so we were able to sort of take advantage of that and get ahead of the curve in terms of virtual hearings, working with third-party service providers, working with partners, working on ways of making sure that we were able to provide virtual hearing services so that we could say to attorneys, to arbitrators, we will be able to continue. And if so, this is how we will do it. Now, obviously, that didn't all alleviate 100% of the concerns. And obviously, during that first wave of issues, we did see certain cases being postponed or adjourned, or arbitrators deciding to move the case to London or to the United States. But then as the pandemic began to progress, and you started seeing cases arise in the UK, cases arising in the US, what we saw was a diminishing number of people who were objecting to virtual hearings, who were objecting to saying that, okay, we don't know when this is going to end now, and now it is a worldwide pandemic. And so the lessons that we learned from doing virtual hearings has been something that we've been able to carry forward all throughout 2020 and now through 2021. And now we're sort of at that stage 2, where we now, everyone I think at this point who is working in arbitration has done some way, shape, or form of virtual hearing, either a fully virtual hearing or a partially virtual one. And now we're looking sort of at the next step. What do we do, not just when hearings can't take place physically, but when lawyers and clients may be physically separated from each other, when parties are physically distant, when people are working from home, right? We are now moving towards a model where international arbitration is becoming fully decentralized. And so now HKIC, in terms of being on the leading edge of that technological development, we're working now on that phase 2, on making sure that we're able to provide services regardless of where the parties are.
Thank you, Eric. It is interesting to hear that parties were considering moving everything to the West in the beginning of the pandemic and then realizing everything ends up shutting down. Meanly, I know you are, again, not last but not least, but we would love to hear your thoughts on this. How has the COVID-19 pandemic impacted you and your profession, in particularly given that it happened in tranches?
Yeah, thank you, Sherry. So first, I agree with all the previous speakers that it changed a lot. Working from home is one of the most popular way for this period of time. And for lawyers, surprisingly, we find it's quite efficient way. So now we just get used to this kind of way, and we find out some efficiency in this way. And for the negative impact on my cases, one is that we have to apply for a lot of extension in court hearing. because in China, during the court hearing, we have a special procedure that the parties will review the original copies of the opponent party's documents. So a kind of cross-examination on the paperwork. And because of the COVID-19, because of the lockdown, we find some difficulties to access to original copies, especially in some foreign-related cases where our foreign clients is located in foreign countries. In that way, the Chinese court will require legalization of those documents in the local Chinese embassy. And the local Chinese embassy just shut down for a long period of time. So a lot of work is done for apply for extension. But luckily, I think either the court or the opponent party are quite reasonable at this point, and we can understand the situation. And in some cases, I had a case where my clients located in Wuhan during that very pandemic period, and they just told us that now the case is on your hand. So maybe please take over the case. We cannot give you full support because we have to spend all our time to prevent the virus because they have to do the volunteer for all the local neighborhood or the local community. So in that case, it's coincidentally, it's also an HKIAC case. So in that period of time, we just, the cases still move forward with the assistance from HKIAC. And we cannot have very sufficient communication with the client because they are very busy and they cannot access to all those documents. But luckily, we still moved on. And in that case, because a hearing was once scheduled and it should be take place in Hong Kong, but because the Hong Kong closed the board, we cannot come to Hong Kong, and we find that we just borrow a hearing room in Beijing Arbitration Commission. So we have the hearing in another arbitration institution. And I think this kind of cooperation is very good among different arbitration institutions. They can just provide extra value to the parties. And even though that we cannot access to the hearing venue in HKIC, we still have very professional and sufficient support from the local arbitration institution. And I think this is a very good hint for the international arbitration community. And actually, my first virtual hearing experience is even back to 2012, so almost 10 years from now. And to me, I'm surprised and very relieved to see the technical development in this field. I still remember my first virtual hearing is a kind of terrible, and I have to submit my closing submission through the telephone call because the internet was so unstable and we cannot use the virtual link, and I have to grab a telephone and make my close submission. But now I think the virtual hearing facilities is very well developed, and we have the specialized technical platform for such kind of virtual hearing. So I think that technical will develop, and there will be very strong support to the international legal community. Thank you.
Thanks, Mainly. I mean, it's extremely impressive that you had your first hearing virtually in 2012. I may get in trouble for saying this. I don't think there's any ICC family here. Oh, you're fine. But I remember back in, what was it, Tim, 2012 or so, ICC had this e-filing equivalent. And then they had to take it down because of the technical difficulties. But we're very happy to say most leading institutions have figured out a new platform or have already had good platforms implemented. ICC is coming on board as well. Kind of turning around to like looking at this from another aspect, COVID. We're all familiar that we've been happily here in Hong Kong, exploring all of the various places that I'm sure you never thought you would see, since you haven't really been able to travel for the last year and a half, or if you have, you end up getting stuck in quarantine for a couple of weeks. But what's interesting is even though we see that there are a number of travel limitations or restrictions, we haven't really seen a corresponding limitation in cases or disputes. I mean, as Helen and Joseph pointed out, we've seen a rise in it. But what I'm really curious to hear today from our panelists, from their personal experience, for example, what sectors have you actually seen a rise in business from? Or what types of legal questions have you been presented perhaps more so now due to COVID than you had been in the past? And I'm going to turn around and I'm going to throw this question first at Helen, if you don't mind.
Yes. Thank you for your question. For the active or the sectors, I have seen a rise, including the following. Investment in medical sector is very active, and also business engaging in online meeting, online education. Those business is also turning good. Also gaming and online entertaining business is also good. And operators for social media and the service provider for all technical support also takes benefit. In addition, from territory perspective, we have found that some of our clients are manufacturers in mainland China, and they have received more orders than before, as China was one of the first countries to resume normal business. That's what I have noticed. As to the type of the legal questions, I would say force majeure, change the circumstance, those issues are frequently being asked by our clients during the pandemic.
That sounds common. That sounds what I've heard. But Joseph, what about you? How about in your practice?
I think I share the similar view with Helen. I remember I purchased my own Nintendo, I think half a year ago. So I think that the gaming industry would be, and also in-house entertainment would be a sector which I think would be having an increase of demands during the pandemic. In terms of legal question, apart from force majeure, I think we have been asked by client about corporate default very frequently over the past last year. I think you have seen many news about corporate default, so I don't need to tell them which company are in problem. But we are asked, basically approached by the stakeholders, including creditors, debtors, potential investors, also liquidators, about matters around corporate default, such as recovery of assets, about enforcement judgment, about restructuring insolvency. So this type of work, I think, are increasing. Apart from the restructuring insolvency or corporate default, we have also seen more questions asked about the privacy and data protection. I think when you enter this office today, you use the Leave Home apps before you can actually be here. I think government around the world has been using this type of tracing and exposure notification apps to actually record the whereabouts of individuals, and that actually raised the concern about privacy and data protection. So we have been seeing clients asking more about this question as well.
I mean, the Hong Kong data privacy, the Act's pretty a high standard. Am I correct? I'm asking, it is a high standard, right? For privacy, yeah.
That's right. That's right. It's different from China, but obviously there's a question about how to balance the one's privacy rights with the interests of the public health. I think that's the balance that needs to be struck carefully.
I mean, it may be an interesting discussion over a cocktail later. If anyone here is from the EU, I'm also quite curious how this interacts with GDPR, because when I was in Europe twice and then quarantined twice afterwards, each of the jurisdictions in Europe, they now also have developed a similar leave-at-home app. But I think in Germany it's called, like, I don't know. But anyways, something to discuss later. I'm now not going to make Min Li go last. Sorry, Eric. Min Li, what are your thoughts? What have you seen in your field that has been on the rise as a result of COVID, or perhaps not?
I think it's due to the internal circulation in mainland or in Hong Kong. I see a rising of the tourism industry and hospitality industry, like those kind of staycation or the tourist group within the mainland of Hong Kong. So this kind of business is quite prosperous. And for the dispute, I agree with Helen, and the most popular question from the clients is always how to terminate the contract, whether it can terminate contract based on force majeure or change of circumstances under Chinese law. And I find that in this regard, I find a gap from different jurisdictions because my clients, quite a few of my clients are foreign related companies. So they always sign those kind of international sales and purchase contract with foreign parties. And sometimes it's not Chinese law being the governing law. And I have to illustrate to them that those kind of force majeure provisions in the Chinese law is not applied to foreign jurisdiction. And in the common law system, it's very difficult to terminate a contract if you do not have express force majeure clause. So there's a kind of communication or education that I have to make to illustrate to my clients. And also I see that a lot of dispute during the pandemic period because people want to make quick money in this period. So the price of those supplies will change a lot even within 1 or 2 days. So some parties, they just enter into the contract very quickly, and they think that they can find out those kind of products like masks or ventilators or like medical gloves, and they sign very quick contract, and they do not make a very good risk management in those kind of contract. So I have received a lot of like question or communication from my clients in this regard. Thank you.
Medical gloves, medical masks, those are quite common. I think there was an article in CNN just the other day on medical gloves in Thailand. Anyway, sorry, I digress. Eric, I do come to you last but not least. What has the HKIAC and what have you seen?
I mean, again, I think from HKIC's perspective, that reflects what Helen and Joseph and Mindy have all said. And I think the disadvantage for HKIC is that we usually see these disputes after they've arisen, when they filed a notice of arbitration. And so, but we have seen, obviously, disputes which arise primarily out of disruptions in the supply chain, for example, sale of goods, especially. One thing to note is that sort of the nature of the disputes that we see sort of change and evolve over time. You know, for the first few months of the pandemic, it was supply chain issues, distribution of medical goods, medical masks. And then as it evolved, you sort of see corporate disputes. HKIC has always had a strength in corporate and financial disputes, but again, you see a record number of cases, and that gives an indication as to the nature and the situation of the economy. Moving forward, I think we have seen online gaming disputes. We have seen disputes arising out of shortages in the supply chain or supply chain disruption, disruptions in distribution of ICs or integrated chips, or disruptions in terms of goods, in addition to corporate disputes. One thing I would note is that there are trends. It's not simply that a year later we're still seeing goods disputes arising out of medical masks. The nature of what we're seeing is changing and evolving over time. One of the advantages, I think, of being at HKIC is we sort of see the macro view of and the trends of how these disputes are emerging and evolving. And though I can't get into the details, I can say that we are seeing shifts and changes and trends in what is now coming to arbitration, what industries are now starting to see disputes arise in terms of arbitration. But I think generally speaking, it reflects what everyone else has said.
So kind of to put you on the spot, and you can tell me that you didn't have an opportunity to really look into this because I didn't give you a heads up, but Min Lee brought up a good point about, the parties entering into contracts quite quickly without really assessing the risk factors and everything, given the situation. Do you know, or do you suspect? Has the HKIC seen a number of disputes arising from contracts that have just been formed recently?
I mean, obviously, I can't go into too many details. I can say that a lot of what HKIC has seen reflects what Minli has just said.
I expect statistics next time, but that's okay. Thank you. I'm curious though, because we have seen a lot of that, right? You see a lot of parties just kind of, because they're trying or they're eager to get that business through now, in particular the PPE segment, the medical glove devices, et cetera, they really don't do a proper legal assessment, as Minli was saying. Turning now to my next question, so I can get back on script so my panelists will feel a bit more assured. Now, despite the limitations of COVID, we all know that there's this due process, perhaps paranoia or factor importance in arbitration. One of the key features of arbitration is that, there's party autonomy, but also there's equality between the parties, and the parties should have a right to have their voices heard. Given all of the issues that have been presented due to COVID, we know that the governments or institutions, law firms, et cetera, they've implemented a number of measures, some of which that Eric has already kind of gone into. But what I would like to ask is, now that we're a year and a half into the COVID pandemic and hopefully on our way out quite quickly, if not one day, what has your experience been with these various implementations? Perhaps what implementations have been helpful? What implementations have you thought been not so helpful? What are your thoughts on things that should be implemented? And with this, I think I am going to start with Minli. Can I jump right back to you?
Yes, of course. Thank you. So I think the good thing that we receive from COVID-19 is that our online technical support is even stronger than previous years. So now in Chinese court, for the case filing system, a lot of local courts can accept e-filing, and also for the arbitration. I know that because quite different from international arbitration, in Chinese arbitration proceedings, we tend to have hearing at earlier stage rather than at the end of the whole process. So sometimes we will have several hearings before the arbitral tribunal issue an award. So in those kind of cases, I see a good development that the parties and arbitrators are willing to have some virtual hearing for the preliminary issues, or like the first or second hearing. So in this way, we can have a more sufficient process in arbitration proceedings, and also reduce the cost for the parties. And for the last or the most important hearing, parties still prefer to have an in-person hearing. So I think this is the good thing that we received from the COVID-19. And also, I think that the international arbitration community is even more prosperous during this period of time, because a lot of virtual seminars or conference can be held. And for myself, I think for every month I may have at least 3 to 4 virtual meetings with my foreign clients, and also with my colleagues who located in different jurisdictions. And it's more easy for us to hold virtual seminars, because it's very the cost is quite low, and we can offer those kind of seminars free of charge for all the participants across the world. So I think this is also something good from the COVID-19.
Thank you, Minli. I think, Eric, I'm actually jump over to you. Can you tell us, what have your users been unhappy with? Or you can also tell us what they've been happy with, or both.
Right. Well, what I can say, I think, is that, we, again, lawyers typically are quite smart, and they sort of catch wind of and understand how situations evolve. So what we from the HKIC have to be, we have to be on our toes, because that due process objection actually tends to evolve over time. When you first started with the pandemic, it was the simple objection that because we cannot participate physically, that there is a violation of due process. And what we've seen, I think, from the courts has both in almost all the jurisdictions around the world is that due process objection being viewed in context of the other option of a complete postponement or adjournment of the hearing. And so what we saw, I think, after about 6 months, 7 months, is that the objection was no longer simply that we can't participate physically. The objection was now evolving to be, we can't participate on equal footing because either one of the parties is in Hong Kong and one of the parties has to participate virtually, or two of the arbitrators are in Hong Kong, but one has to participate remotely. And so we have seen sort of a change and an evolution in how that due process objection is being raised. And what that means is that from an institutional perspective, what we're offering and how we're offering it continues to change. Whether it be, allowing, even if two parties are in Hong Kong, one party being, separated out into different hearing rooms from the arbitral tribunal so that nobody is in the same room as the arbitrators, changing how our interpreters are set. And this is a continuous process. This is based on feedback from the arbitrators, feedback from the parties. And every time we have a virtual hearing, we also reach out to the parties and to the arbitrators and we ask them, what worked? What didn't work? What would you change? What would you like to do better? And so it's more than just simply saying, okay, we've developed virtual hearing services. This is a one-size-fits-all situation, and everybody gets the same service. It's not actually true. The virtual hearing service is much more close to a bespoke solution, where we have a digital projects manager. At HKIC, that's Terrence Chan, who joined us last year. And we have a consultation session with the parties and with the arbitrators. We follow up with them, over the course of the hearing. We arrange the testing sessions and we make sure that we understand what can be improved so that the next time we do it, we're able to do it better. And that's because this is a continuous process and we have to evolve, because otherwise we're going to get caught by surprise by one of these due process objections which has arisen. And we don't want that. So we make sure that we're able to keep our services updated and evolved based off of continuous feedback from the parties and the arbitrators. As to what works and what doesn't work, that's different for each party. One party may say, I don't want all the arbitrators to be in the same room. I want them all separate. And then other arbitrators says, well, that doesn't work for us. So it really is sort of being in the middle ground of that and making sure that you come up to a solution which is acceptable for everyone. Because otherwise, you don't want someone walking away unhappy, because that could lead to further objections down the road.
Okay, so now I'm going to jump to you, Helen. Maybe what's your experience coming from, legal counsel, but also from an independent arbitrator, or from your role with the ICC? What implementations have you seen, and how have those gone in your view?
Yes, I just want to share with you my experience in handling one of the international arbitration case. I actually agree with Eric on how arbitration institutions adopted rules or measures in order to make the arbitration proceeding continuing. Many arbitration institutions publish their own measures to cope with pandemic. For example, ICC also issued its guidance note on possible measures aiming at mitigating the delays generated by the pandemic. Actually, I noticed one article in that practical note which suggested that if the party would like to engage experts, and the experts need to have on-site inspections or requiring traveling to another jurisdiction for inspection, you can issue a joint expert report, working with both foreign expert and also local expert. That suggestion actually, inspired me in handling that case. We encountered a difficulty to invite our U.S. technical experts to fly to China in 2020 in June. It is simply impossible for the U.S. citizen to fly to China in June for on-site inspection. So we've worked with local expert and US expert and issued a joint report, and the tribunal accepted that joint report. So I want to share this experience because I think even after pandemic, if we can spend less time in traveling and try to work together from different locations and jurisdictions, it may save cost and time.
Thank you, Helen. Joseph, what have you seen here in Hong Kong, maybe in particular the courts here?
I think in the early days of COVID, Hong Kong court has effectively shut down for some time. I think there was a period of 3 months where the court was not actually functioning. And that basically is not sustainable. I mean, when you can't have these administrations of justice suspended for a prolonged period of time. So they slowly implemented a number of measures to resume business. They have the cloud controlled management, they have the social distancing arrangement, but more importantly, they introduced the remote hearing, the virtual hearing. Initially for some interlocutory application, but recently they tried to expand that to trial, as a part of the trial. But there was a quite recent court appeal case in which the court maintained the traditional view that when it comes to witness testimony, they insist of having the witnesses coming to court, because the court said, well, in taking evidence, the atmosphere of the court is important. The court is more able to better assess a witness credibility by observing its reaction to questions. So the experience we have in arbitration suggests that actually with the use of better technology, if the remote hearing are properly conducted, this concern could be addressed. And coupled with all other benefits that remote hearing that can be brought in terms of cost and time saving of the parties and the counsel, I think the remote hearing should be a method that could be used for future dispute resolution, not only in arbitration but also in court proceedings. And the experience in UK and also in Australia actually can prove that this can be achieved. Because over the past year, I think courts in UK and Australia have been forced to move towards the remote hearing. Initially, as in basically a no option choice, but eventually they start realizing that actually the remote hearing can be as fair and as open as physical hearing. So I'm hoping that this experience, together with all other benefits of remote hearing, can make a remote hearing a new trend for dispute resolutions in both litigation and arbitration.
Well, you have taken me wonderfully to my next question, even though you've answered part of it. But in order to make sure that everyone who is here in person is still awake, I'm going to conduct an in-person poll, which I'm so sorry for my users online. For my users online, what you can do, and I've purposely done this, you can raise your hand, because I think there's the raising the hand function. So the next question basically, I've raised my hand, sorry. Yeah, this is why I personally think remote hearing should not be here forever. Everyone here, Eric mentioned at the beginning of this conference or this panel that it's very likely that somebody or all of you have already taken part in at least one type of a virtual hearing, case management conference, et cetera. And I'm actually curious to see if that's true. If you have already experienced a virtual hearing or case management conference, something along the lines in relation to arbitration or litigation, raise your hand. Oh, you guys are awake. Okay, that's not everyone. That is not.
Mostly of this half too.
Ooh, I've got like 3 people online. Oh, but that's not good of everyone, man. So this is definitely not even. We're very well attended. Don't worry, you guys can't see this part. Okay, so it looks like less than 10%. Matt, did you want to say something? No. Oh, okay. So that's not okay. How many of you here have purposely, let me rephrase that, have at the instruction of your clients or as a result of what you've heard from the parties, delayed a hearing because you wanted to be in person rather than online? That can't just be 1, 2, 1, 3. Okay, there. Okay, so the opponent. So maybe not at your own choice. Okay. So, anyways, I mean, with me, yes, I've attended virtual hearings before, but I have to be honest, they were definitely not my taste, and I again don't think I would like to continue it. But now that we are on the topic of virtual hearings, I've been hearing left and right that this is going to be the new norm. And for the time being, it is the new norm because, as we can see, COVID isn't leaving us yet. My question to my panelists are, what are your thoughts on this new norm? Joseph, you've already kind of given us yours, so I'm going to skip. Helen, I'm actually going to just jump to you and let us know, what do you think? What about this new norm, or what about virtual platforms?
As I already mentioned, I think it will remain uh, the virtual hearing. And I conducted several online virtual arbitration and the court hearings, international arbitration and also PRC court hearing. All went very well, very smooth. So to be honest, I like virtual hearings more because, the following reasons. First, no need to travel outside China, and it can stay in the office, which is a comfortable environment that you are familiar with. Secondly, no need to adjust your, time difference. The schedule of the hearing accommodate, or if the schedule of the virtual hearing can accommodate all participants different the time zone well. And also it can save the travel time. So I think the virtual hearing will remain even the pandemic is over. That's my personal view, and I would like to hear views from other panel speakers.
Helen, I'm going to keep it on you really quickly since you have had a significant number of virtual hearings. Do you find, I mean, so Joseph mentioned earlier, what there's a lot of people who want an in-person hearing, mainly because of witness statements, witness testimonies. You've gone through this also. How has it been for you? Have you noticed that perhaps cross-examination, if that exists, I mean, in arbitration, it should exist. Has it happened less? Has it been more or less effective? Or do you really not see a difference with the fact that it's a virtual hearing?
We had the full virtual hearing with factual witnesses and also technical experts, legal experts, evaluation experts. All those witnesses were cross-examined through online means. It went through very well. I don't see, and I haven't heard any complaint from my clients or the witnesses being cross-examined, saying they don't feel comfortable by using this online virtual means to conduct a hearing.
Okay, so Joseph, I'm going to jump this to you. Have you seen otherwise from experience, or do you have some similar reactions? I mean, if I was a witness, I would prefer being online. That I will admit.
I've done 2 cross-examinations of witnesses last year by way of video conferencing. I think that after I've done the first one, I feel that the question that I prepare is not good enough because that is designed for cross-examining witness in person. So obviously some adjustment need to be made when it comes to cross-examination, but I think that could work equally well. But the essential skills are the same, but somehow you need to adjust it to a different environment. So some adjustment need to be made.
But do you feel, and I mean, maybe I'm wrong, maybe nobody agrees with me on this, but as an American or as a common law American, we like to be in the courtroom or we like to be in the hearing room because we get to really see how the witness is reacting, whether or not he or she is squirming, if he or she is looking around for answers. I mean, I know on the screen you can see if the eyes go elsewhere. Do you ever have suspicions that they're perhaps reading or somebody's behind?
This is one of the questions that I asked at that cross-examination. So that I was suspecting someone was behind the computer screen to coach the witness. So, but there are basically procedure for making sure that would not be happened.
Fair point. So Eric, what about from the institution? What about you? How do you guys are operating hundreds of online hearings? How do you ensure, I mean, I'm going to take you off the cross-examination part, security, cyber attacks. How do you ensure everything is indeed confidential? And would you like to use mine?
Yes, maybe.
There you go. I'll happily use this one.
The battery's out on that one.
Okie dokie.
So I think from the institutional perspective, quite obviously, we believe it's going to stay. I mean, we've last year invested in building a virtual hearing suite in one of our hearing rooms specifically so that it could act in support of virtual hearings, and that to include multiple cameras to address the concerns about witnesses and their environment and things like that. Multiple screens to make it easier for arbitrators to see. So we have put real money and real investment into making sure that we provide physical services for virtual hearings, which are able to support virtual hearings. We wouldn't do that if we didn't think that virtual hearings were going to be a tool that will remain even past COVID. Now, I mean, the concerns which you've raised in terms of witnesses and coaching and all that stuff, it's not an uncommon objection, and we get that in fact quite a lot with 117 hearings being last year and 80 of those being done virtually. It's not the first time we've heard allegations or accusations that a witness is being coached, but there are ways and measures which have been taken to address that, whether it be invigilators, either neutral or from the other side's firm, sitting with the witness to ensure they're not receiving messages, to 360-degree camera views, to multiple camera views, depending on the nature of the hearing or where the witness is testifying from. We've seen those measures be very effective. Now, obviously, I think some people may say that there are some complaints or with cross-examining witnesses. What we've also seen is that some lawyers who make a living out of cross-examining witnesses say they actually prefer virtual hearings because they do get a closer view of the facial features. They get to see the eyes moving, the face moving, the micro expressions and things like that. I had one lawyer tell me that they liked virtual hearings because they found it better to fix the witness's attention, because unlike in a real hearing where you're about 10 meters away from where the witness would be, the witness is seeing your face up close on the screen. And he was very good at fixing that witness's attention because he knew he had full command of that witness's field of view, right? And so it really becomes a personal style thing. And this is also one of the reasons why I said, from HKIC's perspective, virtual hearing services are a bespoke service. If you buy a suit off a rack in Marks and Spencer's, there's going to be certain things you don't like. The fit's a little wide, it's a little too short, the cuffs are a little short. If you have a bespoke solution, you have someone working with you to make sure to address your concerns, to understand what's going on. These are things that we can at least alleviate or address when devising the virtual hearing solution. I think that's generally why our feedback after the virtual hearing from parties and arbitrators has generally been very positive.
Sorry, you've been accused of turning off the mic. But it's flashing, guys. I think it means the battery's dead. Oh, it's green now. Make me look bad. Here you go. Eric, I was listening. Thank you. Minli, I'm going to turn to you, but I'm going to kind of give it a little bit of a twist. Since you have clients that you advise, both domestically and international clients on PRC law, given that I would assume that you can't see your international clients that are not based in China, I assume a lot of your legal advice is now given over the phone. Emails would say you that is the same. But what happens when you have, for example, conferences, case management conferences, hearings where your client's not with you? Have you seen any, how has your experience been in these types of situations?
Thank you. I think these are good questions, but actually most of my cases, when I go into the hearing room, my client is not with me. So it's always the lawyer who represents the clients in the hearing. And before the hearing, I will have very extensive communication with the clients and tell them what's the potential situation in the hearing and what kind of question that the arbitrator or the judge may ask, and what kind of answers we should in response, especially if it's factual questions. So I just use like discussion in advance to solve those kind of problem. But another point, it's not a response to a question, but it's based on my experience. Because Helen was mentioned that the virtual hearing may help us to conquer time difference in those kind of cases. But my experience is a little bit different, or even the reverse one. I still remember my first virtual hearing back to 2012. In that case, it's a London arbitration. So because the opponent party and the tribunal are located in London, so that they attend the hearing in person. That means we have to follow the London time to take the hearing. And in that case, the hearing lasted for 3 days. And for each day, we begin at like 6 p.m. In Shanghai and end around like 3 a.m. in Shanghai. So for 3 days. And for the daytime in Shanghai, I still have to go to my office to handle case because I cannot tell my client that, oh, I have to sleep because I have another hearing for my another client, so I cannot handle your case in the daytime. So in that case, I just have a very like hectic moment. So in that case, for me, I think if the parties are in the different time zone and they have a lot of like time gap from each other, sometimes the like reasonable hearing time may be reduced. Like if for parties located in Shanghai and New York, maybe you only have the evening, like 4 hours per day to have the hearing, which means the hearing length or duration will be prolonged. But taking account for the advantage that the virtual hearing may bring to us, I think parties sometimes may also want to compromise to accept those kind of disadvantage, because every coin has two sides. We cannot have a perfect hearing. Yeah.
All right. Actually, Minli, if I could just maybe address that. One thing we found quite effective, and which we're actually seeing in a lot of the virtual hearings we're doing these days, is staggered and alternate hearing times. Because obviously, one thing you can't get around with a virtual hearing is the different time zones. So if you have a party in London, a party in California, a party in Australia, and they're all in one hearing, there isn't one good time for everyone to participate. And what we've seen a lot of the arbitrators do, especially ones who have done a lot of virtual hearings, is to say from Monday, we'll be sitting 9 to noon on Eastern Standard Time. On the next day, we'll be sitting Hong Kong hours. Maybe the next day after that, we'll be sitting Australian hours. Now, how you stagger those times differs from arbitration to arbitration. And we've seen some arbitrators dictate it around their own schedule, which usually tends to draw some objections and complaints from parties. But one thing we've seen some arbitrators do is stagger those times around the witnesses. So, for example, if a claimant's witness is based in California, that the hearing hours are set around that witness's time. And that sort of alleviates some of the concerns and alleviates potential due process objections, one of which is that the witness had to testify late at night or outside their normal hours. And so if you have that situation, one thing we have seen is staggered times tailored around the witnesses. And that seems, although not obviously ideal in a lot of aspects, to have solved some of the issues around time zones.
So my IT team, this is now flashing. Just FYI. I'm going to actually skip to another question first, since we're talking about virtual and remote hearings, and actually come back to the audience again. You guys virtually as well. Now that we, I think, have kind of established virtual hearings, I mean, they existed years ago, and it looks like they're here to stay. Do we actually think that this will impact a party's choice of a seat of arbitration? Now, raise of hands if you say yes. Okay, now when I say no, all your hands better go up. uncertainty. Helen and Minli, I don't know if you guys can hear me, but now both mics are gone. So I love IT.
Oh, it's on again.
Oh, it's on again. Sorry. Joseph, I just wanted you to walk. Well, now we see clearly not everyone here is here to vote. I don't think anybody in my audience online voted. If you think it's going to change the seat of arbitration choices by parties, please raise your hand if you're still listening and not recording. Well, I would like to point out that nobody online has raised their hand. I thought this was a good question. Okay. Well, Joseph, why not?
Okay. I think the virtual hearings, to a certain extent, affect parties' accessibility to a place for hearing. But the seat is not the concept of the location of hearing, a venue of the arbitration. It's more about the nationality of the award, the procedural law that would be applicable to the case, which court has supervisory jurisdiction. So these are more important consideration, unaffected by virtual hearing. So from that perspective, I think it's unlikely that virtual hearing will have its material bearings on parties' choice of seat.
Thanks. I'm just going to switch it over. Helen, what are you, I mean, you did not raise your hand when I said, yeah, if you agree, raise your hand. So what are your thoughts?
But it's okay. This is indeed a very good question. And this question actually pushed me to think whether it is possible that the parties in their arbitration agreement simply say that the arbitration hearing should be or shall be conducted virtually without specifying the arbitration place. So surely your question is whether, you know, the conducting hearing virtually can, you know, allow the parties to rethink the arbitration place. But what I'm thinking is whether, you know, the party simply ignore the arbitration place, simply say, okay, we conduct the hearing virtually, because normally the party will say arbitration in Shanghai or in Hong Kong. But if, you know, hearing can be conducted virtually, maybe the party simply forgot to include a place or the name of the city in the arbitration clause. So if the party do so, it leaves to the question to the arbitration institution whether arbitration institution will recommend other options or standard arbitration clause to the parties to deal with such possibility. And also whether it is possible to suggest the party to simply include the supervisory report in the arbitration clause instead of saying arbitration place is where. So that's sort of the question I'm thinking.
Eric, your thoughts?
Well, I think this is actually a question. I think it is a really good question, and I think it is so good. In fact, I think ICA has dedicated an entire project to looking at this issue. I think the ICA has just released statistics on a year-long study on a right to hearing project as to different seats of arbitration and whether or not there is a right or a demand that there be a physical hearing in those jurisdictions. I think that was led by James Hosking of Chaffetz Lindsay and a couple other people with ICA. And those reports, which HKIC and Hong Kong took part in, are now public. And what you've seen, I think, is that there are some seats, for example, I believe in Northern Europe, where there is a right to a physical hearing, where virtual hearings are discouraged. Now, it's too early to tell whether or not that's going to affect their status as a seat of arbitration. And realistically, there's probably a lot of other factors which go into it. From the HKIC's perspective, I think what we see virtual hearings is again, another tool in the toolbox. If it helps us do things faster, if it helps us do things cheaper, then it's a service we should be providing, right? And if offering services faster and cheaper provides a competitive advantage in determining whether or not you choose Hong Kong as a seat of arbitration, well, that's something which has to be taken into account. Will virtual hearings do that in and of itself? Probably not. But what I think it indicates is a focus on making sure that parties are able to get their case heard and get it heard in an effective and timely manner.
Mine works now. Minli, I haven't forgotten about you, but I'm assuming you're on the same boat of this not changing anything. And in the interest of time, I will jump to the next question, but I will first say that this question was not, I didn't realize that there was already a task force or a decision on it. This came from an in-house perspective, because a lot of times in-house, you have in-house lawyers that aren't very familiar with what the importance is of a place of arbitration. And from my experience, whether it be when I have clients or when I was in-house counsel and my colleagues in the legal department, they oftentimes chose seats of arbitrations of places where they wanted to visit. I'm so serious. I actually had a Chinese client that told me that they wanted the seat of arbitration to be, I think it's Mauritius, just because they wanted to go down there. And we had to explain, well, one, it requires a dispute. Two, you actually have to then commence arbitration. And three, you don't actually have to go. But I mean, this is where my question came from. I'm glad everyone had good answers or thought it was a good question. I'm going to leave with one final question to our panelists, because interestingly enough, I was able to cover the whole hour. Future of arbitration. This was the whole panel name, right? The whole panel topic. What do we think is the future of arbitration now that we've had this COVID pandemic, and we can't even say it's over? But it would be nice to have some thoughts from the four of you. I'm going to start mainly with you because I skipped you on the last question.
No problem. So I think the future of arbitration, I now see there is a promotion of growing arbitration in international arbitration community, and I think this is a good direction. And also we have good experience and lessons learned from COVID-19 for those kind of virtual hearing. And I think for the future hearing, maybe we can have a hybrid one. So for a lot of like procedural ones or like the simple or straightforward hearing, you can have virtual hearing. And for more complex cases or a part of more complex issues in a very big arbitration case, then you can have that kind of that kind of part split from the other part and have an in-person hearing. And like the cross-examination, I think for those kind of like technical issues or legal questions, sometimes you can have experts to be your witness. So in those kind of cross-examination, maybe virtual hearing will not bring a lot of difference because they always tell the truth. But for some factual witness, sometimes you want to give more like pressures to the witness, like the tribunal to see the whole, not only the facial expression, but also the gestures of that person. For that part of it, cross-examination, maybe in-person hearing may still have some advantage over the virtual hearing. So I think we will move away that we are more open-minded and can have some mixture and take advantage of those kind of good things and reduce or minimize the disadvantage for the different approaches. Thank you.
Thank you, Minli. So Helen, we know you like remote hearings, but what about your thoughts? What are your thoughts on the takeaway of what is the future of arbitration?
Well, just as I said, virtual hearing will stay, and it is better for the parties to specify in the arbitration clause that they will agree to conduct a hearing virtually, because we encountered cases where the respondent tried to persuade the tribunal for not conducting the hearing virtually, but the tribunal rejected such position. So it's better, say this clearly in the arbitration clause, or at least include this as an option. Secondly, as we encountered many, we handled many cases hearings conducted virtually. And we have seen the tribunal adopted different protocols for conducting virtual hearings. So I'm thinking maybe arbitration institutions or IBA arbitration committee, which is the committee issued full guidelines in relation to conducting international arbitration, may adopt a universal guideline or practical notes on the protocol to conduct a virtual hearing. This might be helpful to promote international arbitration or to promote virtual hearing.
Thank you, Helen. Okay, so I'm going to now come to Eric.
Right. I think I maybe mentioned this in my answer to the first question, which is that I think we see virtual hearings sort of in 2020 as being a sort of a stopgap. But now that we're past that, what it really should be seen as is sort of a phase one in terms of providing tools to the arbitrators and to the parties for a modern situation. And let's be honest, things move forward. They very rarely move backwards. You're dealing now with an arbitration landscape which has to deal not only with the COVID-19 pandemic, but also green arbitration. We have to deal with the real impacts of climate change. Is it environmentally feasible to fly to London, 15 parties, experts, witness, and counsel, some of whom will be there for a day or even less? Virtual hearings provides a tool for arbitrators, for parties, for counsel, for appropriate situations. And I think you're going to see in the future a consolidation of the various different types of virtual hearings towards the middle. You're not going to really have a fully virtual hearing where everybody has to do it from home. At the same time, you're probably not going to have a situation where if everybody's in the same location, they still have to be separated due to social distancing. What you're going to see is much more of the hybrid hearings, where one party or two parties or a witness or multiple witnesses are located in a remote jurisdiction. It just simply isn't economically or environmentally feasible to transport them to the hearing location. And that's where virtual hearings will come into play. You're going to see, I think, a consolidation of standards. You're going to start seeing the different guidelines and institutional notes, just like Helen had mentioned, consolidating and standardizing towards a single standard, which can then be used by arbitrators. Helen has mentioned putting virtual hearings in the arbitration agreement. We've also seen that, as an option in procedural orders number 1. Setting it out right at the start with the parties, once the dispute has arisen and the arbitrator's been appointed, to say, look, virtual hearings may be an option that we can look at. Not saying we're going to do it, but you have to consider that it's a tool for us to use. And that's the takeaway, I think, is that technology is a tool. Technology is there to help enhance the ability for the arbitrator to decide the matter and for parties to advocate. And if we look at it in terms of what a tool can provide, then we can look at it and say, this is what we have now, this is how we can make it better. And I think we're at sort of that phase 1 point where virtual hearings are now entering a maturation stage, and we have to start looking at what can we do next.
And thank you, Eric. Last but not least, Joseph, what are your thoughts?
I agree with Eric. I think there will be more use of new and better technologies in arbitrations. We have made a lot of changes during COVID period in terms of how we conduct arbitration. We have electronic filings, we have electronic review documents, we have 360-degree camera, we have multiple screens, we have virtual hearing. So all this actually made the arbitration more efficient. And I think these new changes are basically irreversible. So when the users are familiar with these new technologies and have developed a habit of using it, it's very difficult to ask them to go back to their old method.
That is very true. I'm clearly outvoted. I hope virtual hearings are here to stay, but hopefully not for everything. Thank you guys again. Does anyone have any questions? Since nobody, you didn't do the interactive with me. But you can ask a question, Mr. Townsend.
Thank you very much. Can you hear me? Matthew Townsend from Fangda Partners. I'm actually one of Helen's colleagues in Hong Kong, so it's nice to see Helen. But we can catch up later. So actually, my question, I was intrigued by the kind of slight difference that appeared to emerge between Sherlyn, who was saying on the one hand that she would, if she was an expert, she would rather be cross-examined virtually than in person. And Eric, who was saying that he had user feedback, factual witnesses. And Eric, who had said that he'd had user feedback from at least some users of the HKIC to the contrary. My experience for the record is that, and that qualifier is a good one, is that certainly when you have an expert witness, as counsel cross-examining that witness, I very much like one aspect. Okay, I'm going to turn so people don't have to see the back of my head. Oh. There's one piece, there's one aspect of the virtual hearing, perhaps not exclusive to a virtual hearing, but that I greatly appreciate, and that is being able to, use the document platform in order to quickly take that witness to different documents. And I found that certainly you can, whereas using paper, for instance, you could take a witness to, for example, 20 documents in a couple of hours. Using the virtual system, you can take them to, potentially 50, 60, if you wish to do that, if that's to your advantage. So I think that that aspect of a virtual hearing, again, not exclusive to a virtual hearing, is a shift in power from the witness to the advocate. And from that kind of platform, I'd be interested to hear what the panelists have to say about how virtual hearings are changing advocacy in court or in an arbitration hearing.
Do I have any takers? Joseph, you're right here.
Obviously, virtual hearing would change the advocacy of some of the counsel. I've seen some counsel in court basically use their demeanor to just intimidate the witnesses, throwing the bundles on the table, flipping over the papers quickly and impatiently. So these all have an effect on how the witnesses would answer questions, how it's viewed when the person gives evidence. That's something will probably be lacking when it comes to virtual hearing. They can't see the counsel's reaction and was not really affected by the atmosphere of the hearing room. That's something I think would be different. Different style to be adopted when it comes to virtual hearing.
Helen or Min Lee, anyone want to address or answer Matt's question? Oh, I love it. See, she raised the hand. Yes, Min Lee, go for it.
So this is how virtual hearing goes. So personally, I think the virtual hearing sometimes can help me to be more focused on my presentation or on my submission, because we now have the electronic presentation of the e-bundle. So I think this is very splendid way to present your bundle during the hearing, and it saved me a lot of time to flip from page to page or wait for the tribunal or the witness that they have to be at the same page with me, and you have all those kind of things on the screen. So this may help.
Helen, you had raised your hand, then you lowered it.
Yes, I actually fully agree with Matthew Townsend, my colleague, and also agree with Min Lee that the online platform, which giving you the screen to show the documents, this tool can attract or easily attract the witness and also the arbitrator's attention to specific evidence. To answer Matthew Thompson's question on how this virtual hearing will affect the advocacy, I noticed that many barristers are not getting used to use PPT or other virtual facilities to demonstrate their position. But maybe with this virtual hearing, everyone have different screens in front of them. Maybe they will start to use PPT, or sometimes solicitor also do the advocacy in international arbitration, and I found it's easier to present your position by using PPT, and the PPT can directly shown on the screen if we conduct a hearing virtually. If we conduct a physical hearing, it depends on the facility of the hearing room and whether the PPT can be clearly shown before the tribunal, and whether the distance is too remote to attract the tribunal's eyesight to view your PPT clearly. But with the virtual hearing, the PPT is simply in front of them, and you can easily attract their attention. That's my point. Thank you, Shirley.
Thank you, Helen. Eric?
No, I think Matthew's point is absolutely correct, and I think those who have had success with virtual hearings understand that advocacy is a little bit different. That you now have the ability to display not just a document, but specific parts of a document to a witness, that you can avoid sometimes, the delaying tactics, whether genuine or not, of a witness saying, oh, I can't find the page. I can't find the bundle number. Oh, I was looking at the wrong document. And I've seen this not just from witnesses, but also judges. Sometimes, I've spent 5 minutes on a submission, speaking from a prior life, and only to find out that the judge was on the wrong chart. And stuff like a document presentation system helps, especially when you're looking at some things like, not to point things out, but like a construction arbitration, where you're not looking at simply an email or a correspondence. You might be looking at a blueprint, and you might be looking at a very complex blueprint, and you can zoom in and focus on specific areas of a chart. And that is a significant saver of time. And so advocacy changes as to things like fixing your eye line with the camera, understanding what the witness will be seeing on their screen. What you have to keep in mind for advocacy changes when you're doing a virtual hearing. But if you master it, then it can be very, very effective.
Okay, so I have not only managed to fill up an hour, I've managed to fill up over an hour. With this, I would like to thank everyone who's come in person, who has come online, and for those of you who have purchased this video on demand, thank you for watching this after the week is over. Today wouldn't have been possible, obviously, without our brilliant panelists. We've got all 4 over there. So thank them again for taking the time out of their busy schedules to be here. Do I do a clap? Sorry. Clap. Thank you guys, obviously the audience. This is an amazing, it was really nice to be able to see people in person and to have you guys in front of me and not give me the interactive panel that I was looking for, but I'm very happy you're here. I have to thank, none of this definitely would be possible without our amazing support team who's in the back, who's been running around and who's had weeks of fun trying to figure out how to do a hybrid conference. Now, Helen and Minli, I would ask you guys to stay online because HKIC has asked that we do a group picture. For my wonderful audience, I would ask that you don't run off to Karis LLP's event because we've got a beautifully catered reception, a cocktail reception from Mama Maloof, I should know this, I chose them. Wonderful drinks, wonderful food, wonderful company to mingle with. I hope I get to actually speak with you guys. Also means you get to take your mask off when you're eating and drinking. So thank you guys again for coming, and we will see you in the back room.